our Fifth Amendment right to silence. We've all been taught this in school. You have a Fifth Amendment right to silence, and if you exercise that right, your exercise of that right cannot be used against you in a court of law. Well, I'm here to tell you that that's only kind of true. It's only kind of true. There are a lot of conditions, a lot of ways to screw that up, unfortunately. We just had a ruling out of the Supreme Court in Arizona that is just another example of constraining this supposedly perfect right to silence and protection from your silence being used against you in court. But that's just what puts this on the radar for today's show. We will be taking a brief look at that decision, but I don't want you to think that what we're talking about only applies to Arizona. The U.S. Supreme Court for many years has been making similar arguments constraining the Fifth Amendment right to silence on a national level. As recently as 2013, there was the Salinas case we'll talk about in a moment. So this is very important, of course, in the context of our core expertise at law of self-defense, which is obviously self-defense law. When you are compelled to use force in defense of yourself, your family, your property, it's quite likely that afterwards you will be questioned by police. And how you conduct yourself in that questioning can determine your legal fate completely independent of the actual legal merits of what you did. You could have used force completely lawfully in defending yourself, your family, and your property, and sink your legal defense, your justification of self-defense, simply by what you say or do not say to the police afterwards. It's as big a part of the fight as the physical fight, right? There's always two. There's the physical fight, and you must win that. That's the most important. If you don't win the physical fight, everything else becomes rather less pressing. But after you've won the physical fight, you also have to be prepared to win the legal fight as well. And a big part of that comes down to interacting with the police in the aftermath of a use of force event. Texas versus Salinas, and involved a defendant. Well, it's described right here. The petitioner, meaning the defendant at trial, without being placed in custody or receiving Miranda warnings, fell silent when asked whether ballistic testing would match his shotgun to shell casings. And the prosecution used that silence, that failure to answer the question, as evidence of guilt. That defendant was convicted, and the judgment was affirmed by the U.S. Supreme Court. This is a guy whose silence was used against him. And one of the reasons or circumstances in which your silence can be used against you is that your right to silence is not automatically triggered. You need to affirmatively assert your right to silence. And until you do that, you don't have that right to silence. And your silence can be used against you. So, for example, you've been involved in a self-defense shooting, maybe perfectly lawful, and a patrol car rolls up, cop jumps out. What happened? And you follow the advice you've heard on the internet your whole life. Don't say anything to the police. Just don't say a word. Well, that officer will be allowed to testify in court that when he got there, he jumped out of his car, asked you what happened, and you refused to talk to him. He'll be allowed to say that. And the prosecutor will be allowed to suggest to the jury that, hey, if this was really self-defense, why wouldn't this guy have said so? Self-defense is lawful. It's not a crime. Why would he not have claimed it was self-defense right then, the first interaction with the police? I'll tell you why, the prosecutor will say, because this defendant fabricated that claim of self-defense. Any of you who had to defend yourself, you would have said it was self-defense the moment a cop came up. That this defendant didn't do that, you can infer guilt. That's not a great place to be. Now, how do you actually assert your right to silence? You say those words. I assert my right to silence. Once you've done that, you can be silent all you want, and that silence cannot be used against you, barring the kinds of complications we're going to see in this Arizona Supreme Court case. But you have to make that assertion unambiguously. If you say, I'm not sure if I should talk, that's not an unambiguous assertion of your right to silence. You have not triggered your constitutional right to silence. And you have to sustain that assertion. If you assert your right to silence and the cops stop talking to you, as they're supposed to, but then you start talking again, now you've waived your right to silence. And now they can use what you say or don't say against you in court. What you say and what you don't say against you in court. So you can see that this is all a bit more nuanced than the generalized internet advice of simply don't say anything to the police. And we spent about 45 minutes in this class talking about various strategies you may want to consider in how you plan to interact with the police in the aftermath of a use of force event. I'll tell you this, you do not want to be figuring it out for the first time when you're being questioned by the police because you shot somebody in self-defense. That's not a good plan. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day Law of Self-Defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there. So let's take a look at this Supreme Court decision, Arizona Supreme Court decision. I should make clear, State v. Melendez. A lot of kind of little subtle things going on here. I found it quite interesting. I think you will too. The bottom line is this is a case in which the prosecution was allowed to argue to the jury that they can infer guilt from the defendant's silence, refusal to answer questions from the police. And you may think, well, that doesn't sound right. Well, it may not sound right, but it is, in fact, allowed. And the Supreme Court decision, so this is a Supreme Court of Arizona case. It's state specific. But the U.S. Supreme Court has also ruled on these questions. I'm not going to talk about that case, Texas versus Salinas, independently because it is mentioned here. And I'm not reading this whole decision. It's 54 pages. I'm just going to read the portions that are relevant to the issue of the right to silence. All right. State v. Melendez. So March 28th, 2025 is when this was handed down, just a few days ago. There's the counsel, there are the judges, and this was an appeal from the Court of Appeals. So the Court of Appeals had said, this guy was convicted at trial. Obviously, you only appeal if you're convicted, right? Melendez. Giovanni Fuster Melendez was convicted at trial. He appealed to the Court of Appeals, and they reversed his conviction. And because that's a ruling of law, not a verdict by a jury, the state is allowed to appeal a reversal by the Court of Appeals to the Supreme Court of the state, Arizona here. And that's what the state did. That's how we find ourselves in the Arizona Supreme Court. So the Vice Chief Justice writes, we consider whether the state violates a defendant's due process rights under the 14th Amendment and by incorporation, the Fifth Amendment right to silence when it comments at trial for impeachment purposes on a defendant's post-Miranda statements and temporary deferrals to answering some questions during an in-custody interview by police. We hold that the state, the prosecution, may use a defendant's post-Miranda statements and his silence, his temporary deferrals, to responding to some questions for impeachment purposes. If the defendant, during the in-custody interview, fails to unambiguously invoke his Miranda rights and keep invoking them, and instead ultimately speaks on the substantive matters raised by the questions, we conclude the state did not violate the defendant's due process rights and affirm his convictions and sentences. So Melendez had lived in an apartment complex. He moved out. A year later, he went back. There was a church at this apartment complex. He parks his car. He walks towards the victim here, AG. Are you the pastor's son? And when AG responded, yes, Melendez pulled the gun, fired multiple shots at the victim. Fortunately, the shots missed. They hit the surrounding apartment building instead. Melendez then ran to his car, drove back to his apartment, and shortly afterwards, officers took him into custody and interviewed him at a nearby precinct. They read him his Miranda rights. He confirmed he understood his Miranda rights. You have the right to remain silent. Anything you say may be used against you in a court of law. Interestingly, they don't say anything you can't say, you don't say can be used against you, but that's the point of this case. You have a right to counsel. If you cannot afford counsel, one will be appointed to you, and so forth. We've all heard the Miranda rights. Melendez asked what would happen if he chose not to speak. The officer said that was his right. If he did not feel comfortable talking, he could say, I don't want to talk anymore. And Melendez immediately replied, yeah, I don't want to talk anymore. And the interview ended. So when he asserted his Miranda rights, the cops respected that assertion and they stopped asking him questions. 5 hours later, a detective interviewed Melendez. Now, they don't make it explicit, but it looks like this first conversation was by a police officer, like a patrol officer. That's normal. So you have more than one kind of interaction with police after a shooting, folks. You have the responding officer. Well, first of all, you have 911 if you call 911, and most people who shoot in self-defense do call 911. That's one kind of interaction with police. Then you have the responding officers who show up in response to the 911 call. That's a different type of interaction that should be handled differently. That appears to be largely this first conversation. They say the officer was talking with Melendez. And then 5 hours later, he gets to the third type of interaction with police. The detectives, the investigators, the professional interrogators is how these guys should be thought of. 5 hours later, a detective interviewed Melendez at the Phoenix police station before asking any questions. He was Mirandized again. And again, he confirmed he understood his rights. And he started answering some questions. So he's talking. If he's answering questions, that means he's now waived any prior assertion of his Miranda right to silence, his Fifth Amendment right to silence. You're allowed to do that. You're allowed to talk. The Miranda just informs you that you have a right not to talk. But if you choose to talk, you've waived your right to silence. Of course, you can assert it again, reassert it. I don't know why you would go flip-flop back and forth like that. But in any case, he's been Mirandized and he starts answering questions. And then he decides there's some questions he doesn't want to answer. So what made you go over there and shoot at him? Well, I don't want to talk about that. Okay. Melendez, I feel a little blindsided, detective, and that's fine. However you feel, I'm not going to force you to say anything you don't want to. Like I said, I just want to get your side of the story. That's, by the way, an interrogation technique, being sympathetic to the suspect. They asked him about his gun. He said he owned the gun for personal protection, 45 caliber Glock. The police could find it in his apartment, which sounds like consent to a search to me. I wouldn't do that either. When asked if he felt he needed to protect himself from the pastor's son, in other words, was this an act of self-defense? Melendez declined to characterize it as an act of self-defense. I still want to hold up on some information. You think the prosecutor is going to want to talk about that? Like we mentioned earlier, if it's a genuine act of self-defense, the prosecutor will tell the jury. Why wouldn't he say so? That's not admitting to a crime. Self-defense is not a crime. And by the way, folks, it's important to keep in mind that anytime you claim self-defense, you are inherently admitting to the underlying conduct. In this case, shooting at someone, right? Because when you claim self-defense, what you're not doing is you're not saying it wasn't you. You're not saying it wasn't me. I have an alibi. Someone else fired those shots. You're saying the opposite of that. You're saying it was me. I fired the shots, but I did it in lawful self-defense. So you haven't confessed to a crime, but you've confessed to the underlying conduct that would be a crime, but for the justification of self-defense. So if the justification of self-defense can be overcome by the prosecutor, what's left? Oh, just a confession to a crime, because it is a crime without the justification of self-defense. So we call self-defense in legal circles, we refer to it as a legal defense of confession and avoidance. You're not denying the underlying act. If you did that, you couldn't argue self-defense. You can't rationally say, it wasn't me, I didn't shoot. But if you don't buy that, I shot in self-defense. That's incoherent, right? So it's confession and avoidance. You're confessing to the underlying conduct necessarily and seeking to avoid legal liability through the justification of self-defense. Then the detective squarely addressed Melendez's actions. Do you understand it's a crime to shoot somebody or shoot your gun at somebody? Well, it's a crime unless, of course, it's self-defense. Melendez, yeah, I know what a crime is and what it's not. Detective, do you believe you committed a crime today? Or was this self-defense? Melendez, I still want to hold myself back on some of these things. Did you shoot at someone today? I want to hold that back. Detective, okay, we'll set that aside. But later, he would say he did shoot. Detective, so I'm just confused. Why would you go over there with a gun? Melendez, that's what I want to say about my relationship with the pastor and the pastor's sons. He shot at one of the pastor's sons. Detective, okay, is there somebody else you were after? Not them. Melendez, sorry, I apologize. I don't mean to ignore you. I just want to pass on that question. Detective, okay, I'll make sure I made that clear. You have no problem with the pastor or his family. Melendez, yeah, I never had a problem with them. Detective, I guess I'll just wonder why you went over there with a gun. Were you upset today? I'll pass. Detective, all right, is there anything else that you want to tell me or you feel like I forgot to ask you about? Did you work today? Melendez, yes, I went to work. Detective, did anything happen before you went to the pastor's house or apartment? Did anything happen today to make you mad? I'll pass on that question. So he answered some questions, arguably waiving his right to silence, and he didn't answer others. Now, they get to trial, and guess what happens? Melendez testifies. He testifies at trial that he fired at the pastor's son, at the victim, in self-defense because he believed that that person was about to retrieve a gun and shoot at him. Now, you may be thinking, why in the world would a defendant take the witness stand? Right? The general advice is not to do that. You take the witness stand, it opens up all kinds of doors for the prosecution, including doors we're going to see here. But it certainly opens up to the prosecution the door of cross-examination. There's lots of things a prosecutor can ask about if you're on the witness stand as the defendant that he would not otherwise be allowed to bring up, like your criminal history, for example. Normally, that would be inadmissible character evidence. But if you take the witness stand, well, you're a witness. And a witness is subject to having their credibility challenged and their testimony impeached by counter evidence, maybe evidence that would not otherwise be allowed in. Now, I've said it before. If you're a criminal defense lawyer, most of your clients are criminals. That's the nature of the business. You don't get all innocent people coming into your office. And because they're generally criminals, they generally have a criminal history that you know is not admissible as evidence unless you put your client on the witness stand, and then it is admissible. And the jury's going to get to see those 30 pages of prior criminal convictions. So you don't do that. You don't open that door. You don't put your client on the stand. You don't have to. 100% of the burden is on the state to prove guilt beyond a reasonable doubt. So normally you won't see criminal defendants take the witness stand. Things get more complicated when we're talking about self-defense cases, because in a self-defense case, the burden of proof is still on the state to disprove self-defense beyond a reasonable doubt. The state has to disprove self-defense. You don't have to prove self-defense, but that's called the burden of persuasion, of persuading the jury of the truth or not truth of the claim of self-defense. But in order to be able to argue self-defense in the first place, there has to be more than zero evidence in support of self-defense. Keep in mind, the role of a jury is to evaluate evidence. If there's zero evidence on some issue, there's nothing for the jury to consider. So if there's literally zero evidence in the record that could support a claim of self-defense, you can be denied the right to say the words self-defense in front of the jury at all. And that might be what happened here. That this defendant, in order to be able to argue self-defense at all, had to insert, it's called the burden of production, had to produce evidence, more than 0% evidence, consistent with self-defense. And that may not have existed in the record, but for him taking the witness stand and saying the words, I shot in self-defense. Once he's done that, he's met his burden of production, and now the burden shifts entirely to the state, the burden of persuasion to disprove self-defense beyond a reasonable doubt. But it's not uncommon in self-defense cases for a defendant to discover he's obliged to take the witness stand in order to meet his burden of production on the legal defense of self-defense, because otherwise it would be denied by the judge, and the jury would never hear the words self-defense said in that trial. But once he's taken the witness stand, he doesn't just get to say the word self-defense and go home. Now he's subject to cross-examination and impeachment. Impeachment is when you've made claims on the witness stand, and now the other party gets to challenge their claims, present contrary evidence, for example. So he takes the stand. He says, I shot in self-defense. On cross-examination, the prosecutor attempted to impeach Melendez's trial testimony. So this is when the prosecution is going to start talking about things that Melendez did not say. For example, all this. On cross-examination, the prosecutor attempted to impeach, undermine Melendez's trial testimony that he acted in self-defense by noting that prior to claiming self-defense in the interview, Melendez decided to pass and hold on many of his answers. So here's the cross-examination exchange. This is a transcript from the trial. Isn't it true that while you were talking to the detective, you never claimed self-defense until after she told you you were going to jail for shooting at the pastor's son? You know all those internet people who say never say a word to the police? Well, some of the words you're not saying are I acted in self-defense. And if you don't say them then and you only say them later, you think you might be vulnerable to this kind of exchange? You're claiming self-defense now, but you never said a word about self-defense before. To impeach your claim of self-defense? Absolutely, you will. So it's one of the reasons that I suggest in our law of self-defense class, our advanced class, April 26th, learn more at lawofselfdefense.com/advanced. I advocate that you consider not just the say nothing to the police approach, but what I call the say little approach. A handful of very specific things to avoid this kind of dilemma when you're faced with winning the legal battle. We spent about an hour talking about that stuff in that Law of Self-Defense Advanced class. Learn more at lawofselfdefense.com/advanced. I think I have a URL. There we go. I'll put the banner at the bottom there. So you never claimed self-defense until the detective told you were going to jail. Melendez, she just happened to bring that information as I was already deciding that it was self-defense. Okay, but after she told you you're going to jail, that's when you claim self-defense. Because she told me, I'll be right back. And she told me it was like my last chance to say something. I decided to tell her it was self-defense. Prosecutor, okay, I'm glad you brought that up. So isn't it true that you were asked probably 10 times direct questions such as, what made you go over there and shoot today? Do you remember her asking you that? Yes. And he never then said the words self-defense. And this is now what he did not say is being used against him. In closing argument to the jury, the prosecution says to the jury, I counted 10 or 11 times that he's asked a direct question. Why did you go over there and shoot? Why did you have a gun? Why did you ask that question? And his answer was something along the lines of, I want to hold that information. I'm going to pass in that question. And this is what prosecutors do, folks, right here. Watch it. Prosecutor to the jury. I mean, if you were shot at or you believe that you're going to be shot at, and that's why you discharge your own gun at somebody 4 times, once the police do get there, don't you want to tell them that you shot in self-defense? Wouldn't you want to say, hang on a second, you have me in handcuffs, you put me in this car, but here's what happened, it was self-defense. You think a jury might find that a pretty effective sales pitch to infer guilt from things you did not say? The jury convicted Melendez on all charges. These would be aggravated assault with a deadly weapon, sentenced him to 7.5 years of imprisonment for the aggravated assault and 2.25 years for each count of endangerment, probably 4 counts. He fired 4 bullets. Reckless endangerment for just firing the shots in this community. And obviously, the jury convicted him because they decided the prosecution had met its burden to disprove self-defense beyond a reasonable doubt. So now Melendez is appealing. He's all the way. He appealed first, so the Court of Appeals got his conviction reversed, and then the state appealed that reversal up to the Supreme Court of Arizona. By the way, his lawyer, when this questioning was going on, when these statements were being made to the jury by the prosecutor, when he was being cross-examined and impeached on the witness stand, and his silence, the things he did not say were being brought up, apparently Melendez's defense counsel never objected to any of that. Folks, that's insane. That's insane. You always object. Even if you are not sure you're right on the merits, you object because your objection is what preserves that question for appeal. And you get to appeal that issue because you preserved it on a much more favorable basis. Often you simply can't appeal the issue at all if you fail to object. When it goes to a constitutional right, the appellate courts will sometimes still allow you to appeal, even though you didn't preserve it at trial by objection. But the standard of review is much tougher. Normally, if you had preserved it, the appellate court would be asking, well, could this have harmed him? Could this have wrongfully led to a conviction? And if the answer is yes, they'll reverse the conviction. You get a new trial. But if you didn't preserve it by appeal, basically the court has to say, this is absolutely why he got convicted. This unpreserved error. It's a very high threshold. very rarely met and not met in this case. So the Supreme Court of Arizona is noting the Fifth Amendment provides no person shall be compelled in any criminal case to be a witness against himself. The privilege against self-incrimination is viable only when the person is guaranteed the right to remain silent. That's Miranda v. Arizona, where we get our Miranda rights. By the way, Miranda was a 5-4 Supreme Court decision. It was this close to not being law. I mean, we all accept Miranda as being, just part of the criminal legal landscape now. We see it in the movies and TVs thousands of times in our lives. But it's not like that has to be the law. Miranda rights being read to you has to be a thing. 4 Supreme Court justices ruling in that case decided it was not a good idea. They were just in the minority. To safeguard this right, the Supreme Court in Miranda mandated that police inform an individual in custody prior to questioning of the following: his right to remain silent. Anything he says can be used against him. He has a right to an attorney, or one will be appointed. This is, of course, the Miranda warnings. These Fifth Amendment protections, however, are not self-executing. A suspect must assert them. And now they're referring to the case I showed you earlier, the U.S. Supreme Court case, Salinas v. Texas. To claim the right to remain silent, an individual must unequivocally and unambiguously invoke it. How do you do that? I assert my right to silence. That's the best way. So a suspect who simply remains quiet has not done enough to put police on notice that he's relying on his Fifth Amendment privilege. So simply not speaking is not an assertion of your right to silence. Once an individual invokes his right to remain silent, police must stop questioning, which they did here, right, with the first interview by the officer. Prosecutors may not comment at trial on a defendant's post-invocation silence after he's asserted his right to silence. However, answering questions after police have properly given Miranda warnings, if you just start talking, constitutes a waiver of the right to silence. It's a waiver by conduct. You don't have to write it down. You don't have to say, I'm waiving my rights. If you've asserted your right to silence and then you start talking, you have waived by conduct your Fifth Amendment right to silence. The court continues, the record belies any claim that Melendez unequivocally or unambiguously invoked his right to remain silent. All he said is, I don't want to answer that question. He didn't say, I assert my right to silence. The state twice issued Miranda warnings. During the first interview, the officer ceased post-Miranda questioning immediately after Melendez said, I don't want to talk anymore. So Melendez knew how to unequivocally invoke his right to remain silent, and that such an invocation would be honored. During his second interview, now by the professional interrogators, the detectives, much more savvy at this kind of stuff, professionally trained to get people to talk. During his second interview with detectives, however, after his second Miranda warning, Melendez elected to proceed with questioning. In light of Melendez's earlier invocation of his right to silence, we cannot conclude he unequivocally or unambiguously invoked his right to remain silent in his second interview, when he stated he would hold or pass on answering certain questions for now. Indeed, Melendez's mid-interview statement that he was willing to continue the interview buttresses this conclusion. He had waived his right to silence, and therefore the protection against his silence not being used against him in court. Melendez's statements are more aptly characterized as tactical deferrals to responding to specific questions than unequivocal refusals to answer. Melendez repeatedly confirmed during his interview at the trial that he merely intended to delay his answers. So he was not asserting silence. He just wanted to hold everything for now. He explained he wanted to wait to explain his conduct until he knew what people on the other side were saying about the shooting. Critically, Melendez actually confessed to the shooting and asserted self-defense during the interview. So confession and avoidance, right? You assert self-defense. You're not saying it wasn't me. You're saying it was me, but I'm claiming self-defense. These statements effectively answered the questions to which he had intentionally demurred. At trial, Melendez confirmed that he had already decided to come in, that it was self-defense during the interview, even before detectives told him he would be going to jail. On this record, Melendez's initial expressed reticence to answer certain questions about the crime until he knew the information police had gathered about the shooting, and his subsequent answers constitute neither unequivocal nor unambiguous indications of his right to remain silent. Moreover, because Melendez never invoked his right to remain silent, I guess in the second interview, tactically delayed his responses, and ultimately answered the substance of the questions during the interview, there was no selective silence. We therefore need not decide whether silence in response to only some questions during police questioning constitutes an invocation of the Fifth Amendment right against self-defense. The things he did not say can be used against him in court. Now, there's a lot going on here, right? The fact that he took the stand and so forth, opened himself up to cross-examination and impeachment. It goes beyond the scope of Texas v. Salinas, the U.S. Supreme Court decision that requires unambiguous assertion of the right to silence. But it's another way that the things you do not say can be used against you in a court of law, both on cross-examination and in argument during closing to the jury. And it doesn't make you look great, folks. I guarantee you it contributed to this guy's conviction for sure. So again, the say nothing approach to interacting with the police in the aftermath of a use of force event is one way to go, right? If your concern is, I don't want to say anything that can be used to incriminate me. If you don't say anything, then there's nothing that can be used to incriminate you. That's true. It's kind of a safe harbor. But the things you do not say can also be used against you. And I think many people don't know that, except, of course, all of you do know that now. That doesn't mean blather away to police. That doesn't mean give a long explanation about what happened without your lawyer present. You have to be much more careful and professional in your approach to interacting with the police, which is, of course, amongst the stuff we teach at our upcoming Law of Self-Defense Advanced class that makes you hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. Saturday, April 26th, 11 a.m. Eastern Time is when we start. And full day, taught live by me, live stream to all of you. Plenty of opportunity for live Q&A. And the people who take it love those courses. We have people take the course multiple times, 4 or 5 times, because it is such a fire hose of information.